All right, well, I'm just delighted for you all here to join us at this Center for Legal Theory event, at which John Oberdiek will be presenting his paper on the wrong in negligence. John is a distinguished professor of law at Rutgers Law School and a director of the Rutgers Institute for Law and Philosophy. And he's also the author of Imposing Risk, a Normative Framework, amongst many other works. So over to you, John.
Thank you, James, for the introduction. Thank you for letting this crazy event actually take place. As I mentioned a moment ago, it's just after 10:30 in the evening for me, but due to a canceled visit from the spring, I thought, and James reached out to me about the possibility of nevertheless seeing if the show couldn't go on in some form or fashion, and so. My thanks to him and to Finna for making this all work, and to all of you for showing up. Most of you in the middle of your day. Steve Smith, thank you for joining me on East Coast time for this discussion. I'm delighted you're here too. So this paper, this draft, that it's my understanding that you may have already read, The Wrong in Negligence, takes up a question that I've long had about most of the leading work done by mainstream, non-consequentialist or right-based tort theorists, all of whom seem to claim that the wrong in the tort of negligence consists in that completed tort itself. That is, the conjunction of all of its constituent elements. So that's injury, duty, breach, actual and proximate cause. And I've never felt entirely at ease by that, because it seems to me that one can wrong another without actually ever causing that other an injury. That is, one can wrong them in subjecting them to an unjustifiable degree of risk. In fact, that's in large part the basis of the book, Imposing Risk, that James referenced in his introduction. So I was troubled in trying to square these intuitions that I had about the moral permissibility and really the moral intelligibility of thinking about risk imposition with the way that tort law is usually understood, and with respect to negligence law in particular. It's a position that is held by, as I go on to detail, folks in Toronto, folks at Harvard, folks at Oxford. It's you can't ascribe this to the Toronto school. This is not an Oxford-specific commitment. It seems to be quite widespread. And although I'm not completely averse to being a butt-see or to being an outlier or a dissenter, it just seems to me that the position is mistaken. And so in this paper, I try to give my account of why it's mistaken. So it's my view that negligence law encodes relational duties of care owed to others. That's something that I share with those whom I go on to criticize. In contrast, those who subscribe to law and economics, for example, will say that the duties that we owe to others aren't really duties that we owe to others. They're in fact duties that drop out of some kind of super value, some kind of impersonal value, whether it's to maximize aggregate goodness or to create conditions for efficient precaution. They aren't first and foremost duties that are owed to anyone. They are rather owed to no one in particular. They're impersonal. It's often then thought by those who reject this kind of instrumental law and economics like picture that another commitment of that position, which is that you don't actually need an injury in order to, for example, efficiently deter anyone. You can just see their inefficient, unreasonable conduct as something that is itself wrong, where you might put wrong in scare quotes in this view. And that's something actually that I share with those who are in the law and economics family. That is, on the one hand, I want to defend the relationality of duty. And in that respect, I'm sharing a great deal with, with those whom I criticize in the paper, mainstream non-consequentialist tort theorists. But at the same time, I'm sharing another position that is not shared by them, but that is rather a central plank in the law and economics position, which is that you don't actually need the negative consequences in order to identify wrongful behavior. So I'm trying to walk this somewhat precarious middle way to try to explain how one can sort of have it all, I guess, or I guess the flip side of that would be to make enemies of every single person. So it's my view then that the wrong of negligence consists exclusively in the breach of a duty owed to another, the breach of a relational duty of care, that one need not wait around for the consequences of one's careless act in order to determine whether one has wronged another. One knows that ex ante, upon the commission of one's act, where the act is described without reference to those consequences. Now, I spend a good deal of the paper trying to rebut the arguments for the opposing position. But before I do that, I try to motivate why I see the world the way that I do. And it comes down, I would say, to the conjunction of a couple of different commitments that I have. One is that it is the primary purpose of tort law to articulate our primary duties. Most going theories of negligence in a non-instrumental or right-based corrective justice civil recourse vein focus a great deal of attention on secondary duties, that is, our duties of redress, how it is that we respond to wrongdoing. This is, after all, how corrective justice is most commonly understood, although some who advance corrective justice say that it has an equally robust primary duty commitment. So this is what civil recourse theory, though, is. Civil recourse is itself an account of secondary duties. Secondary duties are very important. They're an essential feature of tort law. Nobody would deny that. But it seems to me that it's the primary duties, the things that we ought not to do in one way or another, that are both conceptually and normatively prior in tort law. So that's the first commitment that drives me to take the position that I do. The closely related second commitment is that I think that the law must be action guiding. So what we want are for these primary duties actually to give us advice when we need it on how to act, on what's right and wrong. And it seems to me that if you conceive of the duties that we owe to others to include the avoidance of the injury, then we don't know whether we have done wrong until we have actually inflicted the harm. And, I quote, Judith Jarvis Thompson, the very general proposition that we don't tend to think that moral permissibility, the permissibility in law either, can stand by and wait for uncertainty to yield to certainty in order to know whether something is permissible or not. We need to know this ex ante. And if we take that position, I think it puts a great deal of pressure on views that would suggest that, in fact, we don't know what's wrong. We don't know that we've committed a wrong. There isn't a wrong until there has, in fact, been some injury that's been inflicted through the careless conduct. So that sort of gives a sense of why I'm even moved to try to take on the characters that I do. But the remainder of the paper, and really most of the paper, is devoted to looking at the specific arguments for this other view, the dominant view, that's given by Arthur Ripstein, John Goldberg, Ben Sapersky, and John Gardner. Now, in many respects, their positions have a lot in common. one observation that I make is that to different degrees, all of them are driven to this position, which I think is mistaken, out of an entirely understandable concern to fend off moral luck-inspired arguments that seem to suggest that there is no way to discriminate between those who are merely careless on the one hand and those who are careless, but then also cause injury on the other. So in Jeremy Waldron's famous account of this, two drivers, each of whom are equally careless, one of whom gets lucky and doesn't injure the other of whom is unlucky and inflicts significant injury and is therefore liable for massive amounts of money. And yet, on his view, they were equally careless. What can justify that? There are others who have made the same point in different ways. And I'll get to those arguments in a moment. But the first target of my criticism, Arthur Ripstein, begins with a somewhat different concern that I try to tackle. And it's what he calls the dismantling strategy. This is roughly the view, which of course I'm guilty of, that to make sense of what's normatively important about the tort of negligence has to involve dismantling the tort into its constitutive elements to figure out which of these elements, duty, breach, actual proximate cause, or them in some combination, which of them are really, as it were, doing the normative work. He thinks that that's just misguided. Now, I must confess that in trying to get my arms around this argument, I had difficulty identifying the argument. Instead, it seems to me, and this is not in the paper, that there's a Weinrebian cast to Ripstein's position of the form that because all of the elements seem to hang together in a coherent whole, where it's unnecessary to sort of look behind the curtain to see where the normative work is coming from, there's no motivation, there's sort of no reason to press further on this, that the tort hangs together entirely cogently, and therefore it doesn't make sense to seek out which component element is actually the most relevant one from a normative point of view. Instead then of trying to deal with that style of argument, which would warrant a different and many papers in their own right probably, I try to get at the position by identifying indirectly what kinds of commitments Ripstein believes one must make if one rejects his argument. And I do that in two different ways. The first is to identify, and those are the block quotes in the paper, a couple of ways where it seems clear to me that he believes that if you opt for a conception of the wrong of negligence, which is not somehow tied to the injury it inflicts such that one can wrong without injuring, one has to therefore give up on the relationality of the tort of negligence. And there are a couple of ways in which he talks about this, right? Being careful as such, or talking about what duties we owe in relation to persons. He uses this language in various ways to sort of signal, it seems to me anyway, and I am doing some, tea leaf reading a little bit in this portion of the paper, but it does seem to me that he believes anybody who rejects his position must be committed to therefore denying the relationality of duty. That's not a commitment I'm willing to give up. That's something that I think is deeply important to the tort of negligence and frankly to morality as such. But I also don't think one needs to give up on relationality in order to give up on the conception of the wrong of negligence that Ripstein himself defends. So one way to do this, and I'll just try to be brief, let me just cite a couple of cases that I mentioned in the book. One is Summers versus Tice. This is a case that's reprinted in every American torts case book. It's a great, colorful case. It's in torts case books to illustrate the idea of alternative liability over alternative causation. The idea that if there are multiple careless actors, but only one of whom has actually injured the plaintiff, and yet the plaintiff hasn't the evidence to identify which of the careless actors did it, then the burden of proof shifts to the defendant. So both will be liable unless one of them can produce evidence suggesting that they are not the one who actually, in this case, pulled the trigger that shot the person. But in the course of spelling out that rule, Judge Carter, the judge in the case, says, in the case of these two hunters, both of whom shot at the plaintiff while hunting, both were careless as to the plaintiff. Both wronged the plaintiff. Now, one case is not enough to show dispositively that this is an idea that is intelligible within the four corners of our law of torts or of negligence law. But it seems to me entirely intuitively plausible that that is the right way to think about it. I go on to talk about Palsgraf. Of course, every torts paper in negligence has to talk about Palsgraf, because it looks like in Palsgraf, Cardozo might be resisting this kind of move, because he talks at various points about the fact that when one acts carelessly towards another, it's a term of relation, and that it consists in a rights violation, which in the case at hand involves some kind of, call it a boundary crossing, but a physical effect on the plaintiff. But as I point out, the language that Cardozo is invoking in discussing all of that, he is doing in the service of actually dispelling a quite different concern, which is that one can bring a cause of action simply for having been harmed. What he's trying to say is there needs to have been some form of carelessness there as well. The long and the short of it in this section, though, is that I don't think that one can glean anything, frankly, about whether the wrong in negligence must include an injury from the fact that all wrongs that negligence recognizes are relational in nature, that these are just orthogonal concerns, and that I think Ripstein is just mistaken in thinking that they are not. But then I turn to what Ripstein believes really leads those like me, he thinks, to challenge the picture of duty that he endorses, and that's this moral luck argument. And as the paper goes on to say, this sort of concern runs across all of the authors who I take up. This seems to be the boogeyman that they all are seeking to slay, and who seems to drive them into the position, I would say, corner that they find themselves in. The thought is basically this: unless one allows, so sorry, let me back up and say, rather, that where two actors are in fact doing the same careless acts, but only one of whom injures another, the only way to make sense of the fact that one could, and only one, could be liable to the individual whom they harm is to say that the duty itself included and made reference to the injury that was inflicted. Whereas if one takes the position that I defend, that the wrong consists in simply breaching a relational duty of care, then it looks like it's very hard to explain how it could be that the particular defendant who in fact did injure the plaintiff owes them something that the other individual, not a defendant, since they did not in fact injure anyone, does not owe to them. There seems to be a difficulty in discriminating between these cases, unless it's the case that you're going to say that injury is part of the duty. Now, in this respect, Ripstein, Goldberg and Sapersky, and Gardner all are making roughly the same general move. They're all taking the prospect of being driven to treat these two careless parties identically as a reason to subscribe to their conception of duty and of their sense of obligation, as including, in Gardner's language, an obligation to succeed, in Goldberg and Sapersky's language, a duty of non-injury versus merely non-injuriousness. And I just think that's all wrong, okay? Now, each set of theorists has subtly different arguments for this, but all of them, I believe, run roughshod over the distinction between duty and liability in some sense. So all of them, in one way or another, take the fact that it is only one who caused harm to another who is liable to the person whom they injured, to entail that then the duty that was owed to the person who was injured was a duty not to injure them, rather than simply a duty to act with reasonable care towards them, or something like that. In this respect, it's sort of surprising, as I suggest, especially with respect, well, honestly, with respect to all of them, that they would miss the import of this distinction, since in one way or another, all of them have made a significant contribution to trying to push back against this Holmesian conception of duty that reduces it to a concern with liability. And I simply think that they are driven to their conclusion in spite of recognizing that there is a difference between duty and liability because of this concern to fend off moral luck-based challenges. Without detailing the Ripstein and Goldberg and Sapersky positions anymore, because they are quite similar, let me spend these last few minutes just talking about the Gardner position, because his is easily the most complex, and I think it warrants its own distinction, its own discussion. So Gardner distinguishes between obligations to succeed and obligations to try. He thinks that a position like mine defends exclusively an obligation to try, whereas he thinks that one must defend the obligation to succeed, indeed as a conceptual matter, that the obligation to try, in effect, piggybacks on the obligation to succeed. So, for example, one cannot try to do something without making reference to the thing that one is trying to do. So there is a way in which the outcome, the object to which one is directing one's attempt, has to somehow take precedence in a conceptual way. So one cannot make sense of the obligation to try without also then recognizing this obligation to succeed. He leans on Tony Honoré, of course, in making this argument. This is Honoré's argument for outcome responsibility, which Gardner sort of repurposes and names the biography argument. It's Gardner's idea that one can't make sense of one's life without understanding one's effect on the world. Now, you might say, well, one can understand one's place in the world without having those effects. One could simply talk about one's actions. And Gardner says, yes, strictly speaking, that's correct, except that you can't even understand your actions, because you can't understand even your intentions without nevertheless still making reference to the outcomes to which they are all ultimately directed. And so there is no way around giving some sort of priority to the outcomes to which one is directing one's intention, one's action, and so on and so forth, one's attempts. And for this reason, he thinks, your obligations in negligence law must be construed as, at least first and foremost, most fundamentally, obligations to succeed, even though he recognizes one can also have an obligation to try. Right? So it's a conjunction that he thinks we have as a duty. It's the obligation to try and the obligation to succeed. There are a number of problems that I identify with the position, but let me just cite two, and then I'll let James offer his comments and open things up. The first has to do with the view's provenance in Honoré's own work. So it seems to me that because Gardner is building on the work that Honoré himself contributed concerning outcome responsibility, he gets himself into trouble. And that's because outcome responsibility was introduced by Honoré to make sense of strict liability. So first and foremost, strict liability, of course, is not fault-based liability that negligence law is. That's not the problem so much. The problem is rather that it's based on trying to make sense of any form of liability. So I think Gardner succumbs to the same mistake that Goldberg and Sapersky do, which is to think that you can identify the grounds of liability and then reverse engineer and read off of that the content and nature of the duties that one has. But I don't think that it's a valid inference from the basis of liability. Perhaps Gardner and Honoré are right about that basis, but that you can't then read off of that what duty one has. It seems to me entirely compatible with Gardner's and with Honoré's position on outcome responsibility, that one can simply have an obligation, a relational duty to others, not to treat them carelessly. And that should one actually injure another in acting carelessly towards them, one can be outcome responsible for that. So we can pick out the individual who actually caused the injuries in a way that, for example, those who are inspired by these moral luck arguments think that you can't. Right? In this respect, I think Ripstein, Goldberg, Sapersky, and Gardner are all right that we don't need to be unduly exercised by the moral luck challenge. But they all try to do so by proving too much, that the duties themselves have to include something like an obligation to succeed, not to harm someone. The other problem that I identify in Gardner's position is interesting because I think, unfortunately, we can't talk to John anymore about this, but he changed his view subtly between the initial paper where he first articulated this position and then his book. And he shifts between what sense of priority the obligation to succeed has. He talks about, at certain terms, in certain points, moral priority. But really, what he comes to see is that it's a kind of intelligibility. It's like a conceptual priority that they have. And here I think we can grant him that. I think we can all accept that there is a sense in which obligations to succeed do have the conceptual priority that he thinks they do, that obligations to try are only intelligible because obligations to succeed are intelligible, something like that. I'm happy to grant that. But it doesn't follow from that they take moral priority. And by that I mean, it doesn't follow from that what we should care about as a moral matter, as a normative matter, is the obligation to succeed. And the analogy that I run to illustrate this point concerns different accounts of moral wrongness. So there are roughly 3 different accounts of moral wrongness. There's fact relative accounts, right? There's belief relative accounts, and evidence relative accounts of moral permissibility, right? Is something right or wrong because of the way the facts really are? Is something right or wrong because of what you believe the facts to be? Or is something right or wrong because of what evidence you have available to you to determine what facts they are? No one in that debate thinks that the fact relative position is right on conceptual grounds. That is, even though it is of course true that both the evidence and belief relative conceptions of wrongness must have as their object some fact that they are trying to take account of, it does not follow from that point about intelligibility that what's morally important is the fact, What's morally important, according to either a belief or evidence relative position, is either your beliefs about what's right and wrong, or what the facts are, or the evidence that you have for what the facts are that have a bearing on what's right or wrong. And in that respect, I think that Gardner succumbs to the same mistake that would be made were someone to say, no, the fact relative position on wrongness has to be right because every other position in that debate makes reference to facts. But that, it seems to me, is not a valid form of argument. The last thing that I do in the paper is just to draw attention to some, I guess, nice benefit, perhaps, of taking the position that I do vis-a-vis certain law and economics arguments. So Jules Coleman famously noted, in sort of trying to take account of what an economic account of negligence says, that they basically identify duties just in terms of what liability rules would be economically efficient, or insert your favorite economic lodestar here, right? But that you read duties off of the liability practices that are best in some sense. Coleman's famous criticism of that move is that, well, no, that doesn't make sense of, call it tort law's self-image, or call it the way that we argue, our practices, because we use duty as, in effect, a fulcrum to get at liability. Right? We don't have liability determine what our duty is. That's sort of the familiar Holmesian picture that law and economics have simply made more sophisticated. I think Coleman's exactly right about that, that duties are normatively and conceptually prior to liability. But what I say, building on that insight, is that if one actually takes the position that I do on the nature of the duties that we have, it actually stops that reverse engineering that is common to law and economics approaches in its tracks. Because since, on my view, wrongs don't necessarily have liability implications, since it's entirely possible to wrong another without causing a harm to them, which could in turn then trigger liability, it's impossible to reverse engineer the duties in the way that law and economics tries to, if you take my position, because there isn't any necessary liability implication to the identification of a duty. And so it just creates this bulwark, a conceptual bulwark, against that law and economic move. That's not the reason to adopt the paper. I'd rather to adopt the position that's more akin to what Hart would say in his debate with Fuller, and saying, no, don't worry, you can be a positivist and still be, an anti-Nazi. But it nevertheless is, I think, an implication of my view that's worth noting. So that was a quick romp through a paper, skirting over a lot of the details, but I'm hopeful that you did read the paper so that my talk made some sense. And I look forward to your comments and to James's.